We'll now move into item G, our discussion, direction, and possible action on the following. 1, amendments to section 406, bed and breakfast establishments and short-term rentals of the zoning ordinance. 2, consider a resolution calling a joint public hearing of City Council and the Planning Commission regarding amendments to section 406, bed and breakfast and short-term rentals of the zoning ordinance and establishing alternative notice procedures. Aaron, you're on.
Thank you, Mayor. Again, Aaron Vanoy, Assistant Director of Planning and Development Services. This is an item that y'all may have requested, I want to say maybe midsummer, to start looking at some of the rules, particularly a 500-foot separation for elementary and public schools and secondary public schools. And so we'll get to that in just a moment. Through this process, we've had a great staff team and the Planning Commission working back and forth to come forward with these ideas. And so that's what we want to talk about today, is have a discussion about the ideas. And then the thing that we're going to really ask for action is to set a joint meeting in January to bring the ideas to fruition in an ordinance form and move it forward. So this is a time for us to clean up some things in our short-term rental ordinance. There are some things in there that we worked with our legal department very strongly with them to advise us on how we should do things based on some court hearings and things that are out there. One of the things that we found that was a little odd in our system that we said we referred to a license required, but we really never issued a license. And so we've changed that language to be a conditional use. A conditional use is a land use designation, so it goes with the land. And so that's really a planning term. The second bullet point, talking with our team that worked on this together, it's been very clear that the intent is to protect our single-family zoning and low residential zoning areas via a conditional use. And so you see those RS1, which is single family, RS2, which is single family and two family, which means single family or duplexes, and RS3 could be zero lot line, townhomes, twin homes, things like that. And then our ranch and estate, our R&E areas, will all require a conditional use. So in addition to that conditional use, all of those properties will have a 500-foot separation between properties, and that's measured from closest property line to closest property line of whichever properties are looking to become a short-term rental through the conditional use process. We have also made under line 1 that 500-foot separation between the properties. We've also added in the ordinance that is not a variable distance, that they could not seek a variance for that. So be thinking about that as for your discussions and directions moving forward. The second item under there is that 500-foot separation from public schools, and we did say elementary and secondary public schools. And we did try to make a designation of a part of the school that's being used by the children and faculty. So if it's maybe a maintenance barn somewhere on the property that's a long way away, we probably wouldn't count that. We're going to count the most used building. Now, I think we can have some discussion there of how do we want to look at those. Our recommendation is what is our greatest concern in protecting these students and folks that are there on campus, being dropped off, being picked up, walking home from school, things like that. So just be thinking of that. Again, that 500-foot separation from whatever that property line from that school is would not be optional for a variance to the Zoning Board of Adjustment.
When you say public schools, what about charter schools? What about religious schools?
We've been kind of given the direction for public schools. Now, some charter schools do receive tax dollars, and I might lean towards Teresa to help me answer this, but usually we look at those that are receiving tax dollars as a public school. Those that only receive private funding are a private school. I do think it's up for a question of how we want to look at it. One of our biggest challenges from the staff side is identifying what is a private school and where are they located at.
And not missing one.
And not missing one.
Too small or something, but it's more easier to identify a public school and where it is. Not that it couldn't be done, but
yeah,
it would just seem to me that you should not limit it to public schools, but you should limit it to all educational schools. I don't know how you define that, but I think any institution that offers schooling, education should be inclusive in this conversation.
Mayor,
Just
especially-
one comment.
Yeah, I was going to say, especially, Mayor, because you're doing this for the protection of the children as well.
Yeah.
So regardless of whether they're public school or private school, they're children, and we're trying to protect them no matter what.
Very good.
Brenda, are we
Go
stopping?
ahead.
If this is a point to discuss this, I'll throw it
Yeah.
up. So a lot of people can throw up a church and a school within a church. I would hate to own a piece of property and then somebody have a church school that they suddenly put into place within 500 feet. I mean, that's some concern there. Another one, my question on the 500 feet separation between properties is if I'm an investor and I want to make a row of short-term rentals, if I bought an acre or two and I wanted to make them all STRs inappropriate, this would kind of kick that out of the system, would it not? I mean, if you were one property owner and you had 5 of them side by side that you were going to manage, this would kind of throw up a flag, would it not?
Yes, if they are all on one lot, then it might be possible, but if
Well,
they're
what if you own
separate
several
lots,
lots?
if there's several lots, then that zoning district is gonna take precedence. So it could be something they need to find properties that are in a zoning district that would remove that 500-foot separation.
Name that district. What would be an example?
So would that be a variance?
That would not be a variance. And so the way, if you look at number 2, it only applies to those 4 categories, RS1, RS2, RS3, and RNE, that
Right.
have the separation distances. Number 3, if you look at general commercial, heavy commercial, office warehouse, office commercial, neighborhood commercial, heavy commercial, light manufactured, heavy manufactured, as well as R&M, which is low-rise multifamily, like the project that was looked at today.
Right.
And then, which is RM1 and RM2 is high-rise. And so there are places in our neighborhoods that are zoned RM1 that could have multiple properties side by side if they chose to, because RM1 allows a varied structure type. It can be all the way from a single-family home all the way to an apartment complex. So there are some opportunities there, but they would be very limited in scope based on where our zoning district is.
Well, and so what I'm concerned about, I've got a constituent right up, not far from the rodeo, across from the grounds in the Cowboy Church, and that person already has 2 that are side by side.
Yes.
And I don't know, I haven't looked at the plat or the lot, but this becomes an immediate concern is, it's a great place to have it because it's got cushion between them and any other existing or close neighborhood. It's a good spot if they put 2 or 3 of those in, but and my lack of knowledge in this area, I'm going to default to you of saying, are those people protected versus something we do today?
They would have protections moving forward because if they're in existence today and are following the rules today, I don't like this word, but they basically get to grandfather their status until they choose to change for some reason. And then that may make them have to come into compliance for some other reason.
Okay.
There's other options, as I mentioned, the one lot. So we've been approached by different folks of, well, how do I do this? So the way the ordinance talks about is if you're all on one lot, and if you think about other communities that may have these, or maybe out in the country, they're one large lot, but they may have 5 cabins, and that's all a short-term rental. That's one short-term rental entity, as opposed to 5 separate ones. Now that changes, hey, I'm gonna maybe replat my lot into one lot or something like that, but there are some other processes that allows that to happen. But the biggest item is, what is the zoning for that area?
And just to reiterate, it says those are for ones that are operating today legally. Not operating today,
Kinda
legally
emphasize that
operating
word,
today.
legally.
Legally.
Well, so to Tom's point, okay, so I have a big piece of property. I'm going to put 5 cabins on it. And because the cabins will be used primarily, let's say, if it was out at Lake Nasworthy for weekends at a time, would that be allowable? And I use Lake Nasworthy, but it could be,
You
But
pick,
that's a good example.
it's a good example.
Don't you have to first, Aaron, wouldn't you have to first look at the base underlying zoning to be able to answer the mayor's question.
Yes, and most of our property out at the lake is RS1. There's a few R&E, there's a little bit of R&M, and some commercial. But if it's
But
RS1,
if there's a few R&M, then we got to talk about it.
yeah,
'Cause
correct.
If there's just one, it's still got to be talked about.
So within the actual language, it's not only the limitation of the zoning, but then it starts limiting how many bedrooms. And I want to say it is limited to 5 bedrooms, and so we would have to determine and make an interpretation, does each cabin, is that 1 bedroom? And so then that limits the volume of people that can be there. Because I know that's maybe your concern that you're pointing at is, well, if I have a 2-acre piece of property and I put 25 of these out there, am I okay? And then you're adding the volume of traffic and potential noise and things like that. And so I think that's a consideration when we look at this ordinance language. What are the protections we're wanting to do, not only for short-term rentals, but for the other private property owners around?
Tommy, I know you had some questions.
Aaron, you didn't mention child care facilities. How does that play into the 500 feet?
We have asked that question, and the thought process now with the group that's been discussing this is, again, does that mean that somebody runs one out of a house that we don't know about? And so the decision as our recommendation coming forward for the discussion is that we would not have those included, because it simply puts staff in a position to make a significant mistake and give somebody a conditional use through a process, and then we find out somebody's operating a daycare, and it's very problematic.
And
It's very hard.
They don't have to register with, I mean, that's something that the city does not track. So it'd be very difficult for the staff to be able to catch all of those and know there was a child day. I mean, that's where the public schools versus private schools also where I was going. Don't set the staff up with so many things that become very difficult for them to catch.
One step, going down the rabbit hole a little bit further, if it is a advertised and signed, there is signage identifying this location as a child care facility, but it still might be in a neighborhood. I can think of at least one over in the Santa Rita area that has been there a long time, but it is in a residential neighborhood. How would the 500 feet apply in that situation?
It would be grandfathered, but what happens if someone wants to open up a new one?
Yes, the new one, yeah. If somebody 2 houses down, could they open it up from?
Currently, the way we have it written, yes, they would be allowed to apply for a conditional use. Now, conditional use is a discretionary decision by the Planning Commission, and that's where the staff works with the applicant to say, here's why it's a good idea or here's why it's a bad idea. And maybe that's a criteria of us making sure that the Planning Commission knows what is around, and we've identified that, and they make the best decision they can. At that point, and we'll talk about it a little bit later, there's always an appeal process that could come before this board or this council and say, okay, what makes sense there? Now, I don't like creating additional processes to solve an issue. How can we write the ordinance to solve the issue? But I think that is something to consider and something for us to discuss further if that's
It
how
may
you feel.
be worthwhile, this would be work, but it may be worthwhile to identify those that are known current child care facilities just to have that information. Y'all may have that already, that are known to be operating as a child care facility. Just so, if nothing, we know where they are at least. And then if this did ever come up, then you all would have the information in order to have that discussion you just referenced with the applicant. Just a thought.
Let me ask another question. Describe what 500 feet looks like. Is it a block? Is it half of a block? Is it 2 blocks? What's 500 feet?
It is property line to property line, so anywhere on that property, even at the back alley or the corner there. So it is a 500-foot buffer around that property. Whatever the shape of that property is, it's that 500 feet. So it doesn't matter if it's linear straight down the block or the block behind you. It is a buffer, and we are working with our GIS department to build those buffers around the known properties so that when somebody looks at the map, they know where that buffer is.
But
Mayor, I just found some common examples for you.
that's what I want.
Half the Eiffel Tower 2 Boeing 777s, 5 garden hoses, or 11 school buses. That's 500 feet.
That's what I needed, was that explanation. Because
you.
when you say 500 feet, you're like, well, how much protection is that?
Haven't been to the Eiffel Tower, so I wasn't aware
Yeah.
that that was,
To
It's 1
Aaron's,
and a third football fields.
yes.
There you go.
to Aaron's point too, and it really to the heart of your question, I think, Mayor, and he referenced it, is it actually linear feet or is it?
No.
No, it's not.
Right. It is a direct line of sight, or as
As the
Rick
bird-
says, as the squirrel runs.
No, I said as the crow flies, not as the squirrel runs.
Because those squirrels are all over the place.
Doggone it, Aaron, I wanted to be the one to say that.
My next question would be, based off of the language that we're talking about and we're asking to have added to this for conversation, is with the previous cities passing STR regulations, Teresa, do you see these suggestions as potential problems as we move down the road? Because we know a lot of lawsuits have been filed against cities who have passed short-term rental ordinances.
Yeah, we tailored this ordinance to comply with those cases that regulate us right now, which is primarily a case out of Austin. There's a lot of cases from other court jurisdictions that are kind of informative, but they're really not binding on us. So this does meet the regulations that we're under right now, but I can't say that protects us from any kind of liability because this is a very hot topic for litigation. And the way that you get sued is you enter into a new provision that nobody else has done. I keep hoping the Supreme Court will look at these jurisdictions who have all these different rules and make a decision. They kind of look at the cases and so far have declined to do that. So we're hoping to have some Supreme Court jurisdiction, Texas Supreme Court decision-making ability and some guidance, or this comes up in the legislature and every session it gets closer to just allowing these by right. So we'll see. But for now, I think this is the best we can do to protect ourselves.
Karen?
Is it correct that the language states in the ordinance, because you don't want to be vulnerable to interpretation, I think is what I'm gathering from Teresa's comment, and this will continue to be a contentious topic for citizens and city governments, probably into the indefinite future. No matter how great the new ordinance is, there will still be questions and concerns. But doesn't the ordinance currently state that where restrictions are in place on land use, the more restrictive shall apply? Meaning, if there's a question, several examples have been given, then the department and the planning commission will choose the most restrictive.
No, I think that's a
Solution.
misinterpretation of what our ordinance says. We have a conflicts of law provision within our code, and what that says is that the more restrictive are imposing the higher standards shall govern. The zoning ordinance is not intended to supplant or replace private deed restrictions or covenants. So what it's saying is that if we give you authority to do something, and we've seen this in other cases, if we give you some authority to do something, but you have a deed restriction that's more restrictive than what we said, you still have to abide by the deed restriction. And the same thing goes the other way. If you have a deed restriction that says it's perfectly okay to have STRs on your property, but we say no, then we're the ones who govern. So whichever is more restrictive.
Thank you. So how can you apply what you just explained to us to an entire development with published deed restrictions? Did I say that right? Because we frequently hear about neighborhoods, Tom has some, I have some, that are older neighborhoods, no deed restrictions are on those neighborhoods and they feel particularly vulnerable. But there are other parts of town where there are clearly stated deed restrictions, and I think the public believes that those are protective. If they don't want to live with STRs, then they don't have to, but maybe that's not the case.
Well, may
those
I
are
ask, okay, let me ask this, Teresa. Okay, so if I lease to someone for 31 days, not 30 days, am I an STR?
No. So back to Karen's point that those are protective. They are protective, but it's not the city's to enforce. All that we can enforce are the rules that we put upon properties. So if you have a deed restriction on your property and Lucy decides to put an STR as your neighbor next to you, then you can sue Lucy because she's violating that private covenant between you. The city doesn't have a role in that, and it's not appropriate for us to have a role in that. Those are unique community restrictions that, quite frankly, communities can be more stringent than we as a city can be. I think the other component of this is the discussion about whether or not those deed restrictions can prohibit STRs has been decided by the Supreme Court. And they said two things regarding that. One, STRs are not commercial. This is a residential use, just the same as if I leased my property for 31 days. That's considered residential use. So they're not viewed as commercial enterprises by the Supreme Court. So the deed restriction would have to be very specific in saying you are not allowed to have this particular residential use for it to apply. We have deed restrictions throughout the community. Some are racially discriminatory, some are just no longer relevant. All of those are for private individuals to deal with. We don't get involved in that, and I would highly advise that we don't, because it opens us up to even more litigation for interpreting a situation that we're not even involved in.
What is the ruling on subletting? So if I choose to lease a project for 31 days, but I sublet to someone for 1 week, is that legal?
I think the subletting would be, for the 1 week, would constitute operating that as an STR. And I know there are a number of operators who do go back and forth. If they can find a long-term lessee, they do that. If they can't, then they put it on the list and they, rent it for the night or the weekend or whatever. The way we're looking at it, I believe, is if you have a period of time where you're leasing it for less than 30 days, you have to comply with our STR requirements.
Yes.
This is such a tough conversation to have, because on one hand, I'm a big believer in private property rights. I think that's a huge issue. On the other hand, I'm very protective of a neighborhood and believe that people move into neighborhoods because they want to know the neighbor and want to know who's in the neighborhood and select certain areas based off of what they want their family neighborhood to be. So it's very a challenging conversation, and even to the point of subletting for 31 days doesn't constitute an STR based off of the issues that Tom brings up, Karen brings up. I think what we really need to do, in my mind, is add as much commentary to this issue as possible before we take any kind of motion or movement on it. I don't think today's conversation should be the only conversation had on this issue. Short-term rentals are part of the new world that we live in, and we really want to make sure that we as a city support the short-term rentals as long as it protects the neighborhood, and at the same point in time understand what private property rights are all about. It's very complicated. It's going to be very emotional. It's going to be, I know you've put a lot of work into it, but I think we've brought up several issues today that add to that conversation, including defining a public school versus all schools, elementary schools or schools of education, regardless of whether they're private, public, or church. Those are just some of the issues. And then Tom's issue of if I have a big piece of land and I put 5 cabins on it, what's the language on that? Karen's points, which were valid points. So if council...
And Mayor, if I may, I have a couple of other slides just to talk about how we're talking about process changes too, because that is also something we hear from our STR operators of, can we get some process changes? Because it's been at times challenging for them to come in compliance and much easier for them just to operate without following the rules. And so we want to make something that makes sense for both. So really this slide talks about where. And so you've got that question of where and how do we determine where. This slide is more about how do we work through the process to help them get there. So through some of the court cases, that number one up there, they basically have said that you can't limit it based on the size of the road, and you can't limit outdoor gatherings on these properties, because if you can have basically a family reunion at your house that may have 30, 40 people, why would you treat a short-term rental any different, is how the courts kind of see it. We have shortened, or we will ask to shorten to the appeal period, and that's really just to get the process moving forward. A 30-day appeal period for this is it seems to just drag it out, and then you have those others that may be, if we have a distance separation, trying to apply. Now they need to wait, and so it's really putting a backlog on getting these processed, the ones that actually meet the criteria. One of the things that we are doing is providing a revocation process of the conditional use through the Planning Commission based on a criteria that would be in the ordinance: failure to pay your hot taxes, failure to do certain things, you failed your inspection, you had too many code complaints or SAPD complaints that turned to be valid complaints. We would be able to bring towards the Planning Commission, we want to revoke that conditional use for that property. And so it would remove that ability for that property to have a conditional use at that time. Any questions on this slide before I move forward? So this is where, Mayor, as you're talking about, we did earlier propose that having a resolution and a joint meeting in January. If we do think that's a little premature, the question would be, do we want to have the joint meeting with Planning Commission just to discuss? The big thing goes back to notices to our community of a joint meeting, because we are set by certain things that we have to notice a certain way for an item like this that impacts changes in several zoning districts or a zoning district like RS1 or something of that nature. And so we have to notify a specific way. So if we feel like this is to delay, we need to know that so that we don't send out notices and we have to do this multiple times.
My gut instinct is delay. I think that's too preliminary or too soon. I do believe the other thing that I didn't mention earlier, but is Tommy's comment about child care facilities, which hasn't been inclusive in here, and I think that has to be a subject to be discussed further and look at what rules and regulations might apply there. But I think requesting this in January is too early.
Okay.
I think there's still a lot of work to be done on it and a lot of additional conversation and clarification, in my opinion. And I would ask council to say what they say. Harry, did you have a comment earlier you wanted to make?
Yes, I did. We've been dealing with short-term rentals in San Angelo about 7 or 8 years. When I first came on council in 2016, we talked about it and then started through this. So it's time to revisit this and bring the ordinance up to where it needs to be. Now, whether we vote on this as it is today or we push it till we get some more information makes no difference to me, but we've got to do something with it. We can't keep it the way it is.
I would like this information to be updated based off of our conversation today, be brought back to us at the January 16th meeting, and then we'll decide what action to take going from there if council agrees.
I would like to clarify, y'all need to tell us specifically what you want us to bring back.
The things we just discussed as part of that ordinance.
So where I would go with that is adjacent STR properties that share lot lines or share property lines specifically, is I think how I would phrase that. And whether they would be
Multiple
inclusive of falling under this or not.
Meaning multiple
Yes.
multiple cabins.
Multiple STRs.
On a single lot.
Teresa, let me go down a different rabbit trail. I know there's a lot of legal activity in Dallas over their STR ordinance. And I think there's been an injunction, whatever. Maybe a delay on our part would help us a bit. It's not going to give us clarity, but it might help us a bit to see where that case goes before we move forward.
Well,
So
that case specifically is about no STRs. The council voted no STRs in a residential area, only in commercial areas. And that's the basis for that lawsuit.
Yes, and the injunction just said the city can't enforce their ordinance until the other issues are resolved. The issue with the Dallas case is that's not our jurisdiction as far as courts
Okay.
are concerned. We're really under the Austin cases and that series of cases, which we're watching to see if there's any decisions made on that, but that hasn't been done. The other concern I have about continuing to push it completely is that we do have things that we know we're not enforcing because we cannot enforce them under the Austin case. So the number of people, I think the road width might be another one. So there's a few things like that the Austin case explicitly said we cannot enforce. So even though it's on the books, we don't hold people to those things. So at the very least, we want to get those cleaned up at some point in the near future.
would it be possible to clean up that which, in your determination, planning department, legal department, needs to be cleaned up for the current state of operations, to go ahead and bring that to us, let us address those, make a decision on those, and then some of these other things that may need further discussion with the planning commission, then we do that maybe in February. That's just a thought.
We can certainly look into that and work with our legal team to see what's the right path to take. If we're just simply striking some text, that might be one path, and then we come forward with here's the real revisions, but I'll take their advice on where we can move forward with that.
I would be
I
open
think
to
we
that.
also want to avoid having to have multiple meetings with the planning commission. So we have to call that joint meeting. So I would encourage you to just do that once. It's kind of hard to assemble everyone. So if we need to punt and bring that all together.
I think we do, Rick. I think
Okay.
we don't want multiple meetings to do it. We want to,
Right.
based off what Tommy said, what other city council
So,
members have offered,
I'll go
get
over-
all that together.
Okay, I'll go over the items that I have listed and also have one question. Do you want all of these items that was listed reviewed by the planning commission before it comes back to you?
I think it should be.
Okay, so
In my
that next
opinion.
planning commission meeting's not till.
It is after your January
Right.
meeting,
So
so
that
you would
means it's
not
gonna
hear it in
push you
January.
even farther.
Yeah.
Yeah, because have been involved and have offered
Yeah.
a
Correct.
lot of input, so I don't think we should be asking for change without it going to them for review and conversation.
So what we'll take to them, unless I've missed one, and y'all tell me if I've got this right or wrong, but one is the item pertaining to multiple cabins or such on a property. How is that treated? Or we'll explain whether that's allowed or whether other guidelines prohibit or allow that, and what their opinion is. The next is to potentially include private schools as well as public schools. The next is whether they want to
Including
include.
churches that
That would be
have
a private
schools, right?
school.
Okay,
Yeah, so public or private school.
okay.
And the next is whether or not they want to include childcare facilities. Is that one y'all okay for them to talk about? And then the last one is anything pertaining to deed restrictions. Do we want that one? Okay. Did I miss anything? Those are the four?
Well, I think mine, just to be clear, was it didn't matter if they were all on one property. They could be several adjacent properties in a row. I mean, somebody could have 5 or 6 lots that are adjacent.
I think that'll most likely be already governed by if they're allowed by right and they're not in a zoning area that requires 500 feet, then yes, you could. But if they're 500 feet requirement and the person just happens to own multiple lots, then that would not be allowed because they'd have to have the 500-foot separation between one STR and the next. I think that.
I don't know if I'm good with that, but anyway, you have the gist of what I'm asking for.
Yeah, you'd have to totally change the 500-foot requirement in that zoning thing to allow, okay, Rick bought 6 lots in a row, and so I can have 6 just because I'm the same owner. I think that, from what I would see, would defeat the spirit of what initially was trying to be done to making them 500 feet apart, unless it's in a allowed by right area. But
Karen?
we can talk, but.
Just confirming that code compliance and enforcement is not part of today's conversation. It'll be part of the conversation with the planning commission when we meet jointly.
Well, and so we can just briefly touch on that, but, at this point, the city doesn't have, we operate on a complaint basis, basically with code compliance. And so we don't have anyone who's doing that, who's going out looking for these or enforcing that. Finance has done a good job of trying to look at, who's paying hot taxes, get those things done. But that will be something that y'all will need to consider and possibly we'll talk about in January at y'all's work session. But if we want enforcement in this area, that means we're really going to have to bring on staff to help do those things.
I don't think we use code compliance in that sense, just as we don't today ask that code compliance drive around every neighborhood and write down the issues that, it is phone call related, right? It's not.
Correct. That's typically how it's done now.
And I don't think we should be asking our code compliance people to be in this management of this issue unless there is a complaint, just like it is for them on all other issues.
The complaints we got, like at the meeting, at the planning commission meeting, were that there are all these ones operating out there. This guy spoke and said, why should I be in compliance when there's 40 others? Why do I bother if you're not going to enforce? So those are the concerns, and where you put it could be decided. But I just want everybody to know, just STRs in general, the planning staff is low as it is now, and the volume of these coming through and enforcing is something our staff really doesn't have the.
But every citizen has the right to ask for code compliance on those issues. So if you suspect someone is operating a short-term rental, you have the right to call and report it.
Correct.
Everyone has that right. And then it's our obligation to go out and seek the information in terms of whether it's valid or not.
That's correct. And that what I was basically just trying to say is that enforcing in that manner, we currently don't have the staff to do that. They're not covering well code complaints coming in general. So anyway, just food for thought for y'all later.
Further, yes, Lucy.
I just wanted to ask, does this include as well as for traffic? I know we've always had good questions about the streets are too narrow or there's no way out, just one way in. Are we going to do any of that? Are we going to put that in any kind of ordinance, or we just?
Well, this really is just a land use ordinance. It
Okay.
really doesn't address all of that thoroughfare stuff. And so there's been a case that says you can't restrict the width of road. That would be some evidence that we may be able to provide to Planning Commission when they make their discretionary decision on a conditional use for short-term rental. We do require them to provide adequate parking and things like that. And so there are some options for them, but I don't know that it would improve those areas that are maybe not quite up to our standards, but it should be something we could look at in the decision process of the conditional use, because that's really important, is why do they approve and why do they disapprove?
Exactly.
Usually that's because of citizens around says, we don't want this, or a distance-related thing. Rarely is it infrastructure, parking, roadways. That may be a complaint, and a complaint to code compliance if it gets to that point. But this really does not address that aspect of it.
Okay, thank you.
Yeah, I do want to clarify, though, that the Austin case is pretty clear that if that's the only basis for denial, then that's not going to be upheld. That's why we're taking it out of our ordinance as a consideration for them. And people can come up and complain about that, but we can't regulate solely on the road is too narrow. The court's reasoning is if it's wide enough for a house, it's wide enough for an STR.
Thank you.
Further comments before we move on? Okay,
Well, thank you all for that direction and discussion. I think that's very helpful for city staff. I know some of the staff members that have been working on this are here, been taking notes, and so we look forward to bringing back information for you. Thank you.
Right, thanks to all of y'all, Aaron, for the
This
hard
is
work.
highly emotional and subject to a lot of criticism on all parts, so thank you.
Mayor?
Yes.
We will need formal action because it is considering a resolution. So
Okay.
if someone can make a motion to deny the resolution, calling the joint meeting in January.
Second. Motion by Tom, seconded by Tommy. Public comment. With that, we'll take a vote. All those in favor?
Aye.
Aye.
Motion passes 7-0.